let's see.
Okay.
I think I should be able to do it actually. So let me just
also
try
make
it now.
you a co-host. And then I'm going to make Elizabeth a co-host as well. All right. So it is 6 o'clock. I want to be respectful. Here, let me turn my camera on so y'all can see me and my headboard. I want to be respectful of everyone's time. And so I need to introduce to you Hopi Fink and Elizabeth Vandenberg, who are from Legal Services of Eastern Missouri. And so they both have been doing work with supporting numerous organizations basically around education. And so they are here to talk to us today about knowing our rights when it comes to some of the issues that we see appearing now. And I will turn it over to them.
Great, thanks, Heather. And it says host disabled participant screen sharing. So I'm not currently able to share my screen. I don't know if you are, Elizabeth.
No, I'm afraid I'm not either.
Okay. I think I was about to be able to, and then something just changed. So I don't know if that has to be switched back, whatever was. I think, okay, here we go. Let's see. Can everyone see my screen? Okay.
Yeah, we can see it.
Great. All right. Well, I'm Hopi Fink. I'm a staff attorney in the Education Justice Program. And I'm here with my colleague, Elizabeth Vandenberg. I'm going to just turn it over to Elizabeth, and we're going to kind of dive right in since we have, we want to respect your time, as Heather said, but we're really grateful to be here with all of you and to have this conversation. It's a really important one. Sorry, I always do that. It's a link. Somebody made that a link. Okay.
Thanks, Hopi. Yeah, like Hopi said, we're both staff attorneys at the Education Justice Program. I'm Elizabeth Vandenberg, and I'll be starting us off here and then handing it off to Hopi. Just to get us started a little bit, I wanted to situate you in where we're coming from. We're from Legal Services of Eastern Missouri.
Sorry, I'm just getting it in full screen mode. Keep going.
And I'll sort of introduce you to us and the Education Justice Program, and then really dive into curriculum in Missouri, the roles of all the different players, the districts, parents, students, and then we'll talk about race and equity, some federal and state considerations, and then open it up to questions. So Legal Services of Eastern Missouri serves low-income individuals and the elderly in 21 counties in Eastern Missouri. We provide free civil legal assistance and holistic social work services for legal clients. So we have an office on the map here in St. Louis, but we also have an office up in Hannibal and in Union. And then you can see on this slide that it's not just the Education Justice Program. We have a lot of units at Legal Services that range from youth and family advocacy to elder law, to public benefits, to housing. We cover a lot of ground. Both in St. Louis and throughout Eastern Missouri. So the Education Justice Program, which is the unit that Hopi and I are both in, started in 2017. We target the root causes of education inequity in Missouri by using a racial justice lens and community lawyering to advance systemic change. So what that actually means in practice can mean impact litigation, holistic social work for clients and their families, community outreach and education, policy papers, and individual legal advocacy. Basically, we work to ensure that every child receives a good education in a safe school. We think a good education is every child's right and shouldn't be dependent on where a child lives or the child's race or ethnicity. I said that we use community lawyering in our work, and what community lawyering means can be media advocacy, door-to-door and virtual canvassing, cold calling to community partners and faith leaders, attending community meetings, know your rights presentations, and concerted efforts to reach groups that we haven't gotten in touch with before. Basically, we hope to work with community to work on the issues that we have and continue to work on, which range from combating the school to prison pipeline, which can mean working on school discipline issues and school resource officers, advocating for access to education, like the right to an alternative education and inequities in remote learning, and protecting the rights of students experiencing homelessness under the McKinney-Vento Act. Now that we're a little bit situated in where Hopi and I are coming from in terms of legal services of Eastern Missouri and our unit, the Education Justice Program, sort of talk about the issue at hand, equity education in Missouri. We're lawyers, so we tend to think of the law. In Missouri, the Missouri Constitution says a general diffusion of knowledge and intelligence being essential to the preservation of the rights and liberties of the people, the General Assembly shall establish and maintain free public schools for the gratuitous instruction of all persons in the state within ages not in excess of 21 years as prescribed by law. And a Missouri state statute says the State Board of Education and DESE are prohibited from mandating the curriculum, textbooks, or other instructional materials to be used in public schools. Local school boards are responsible for approving curriculum. So that means a lot of different things. Taken together, it means that because the state constitution gives the General Assembly the power to maintain public schools, the legislature is able to pass bills related to specific curriculum requirements. But in general, local school districts have control over curriculum. So generally we look to school districts. Most school districts have a director of curriculum and a curriculum writing team, board policies and regulations about curriculum generally, board policies and regulations about teaching controversial subjects. For example, Rockwood has a couple of policies on challenged materials and teaching about controversial issues. And most school districts also have a school district attorney who can answer questions related to what educators can and can't do in the course of their employment. So for the educators on the town hall or those who are interested, as employees of their school districts, public school teachers are legally bound to follow their school district's board policies, including those related to curriculum. I think most of our instincts is to think of the First Amendment. And it does protect the free speech of a teacher if they're speaking as a private citizen on a matter of public concern. So basically not in their capacity as a teacher, and about something that's of interest politically, socially, or otherwise to the community. But when teachers are speaking as part of their job duties, like when they're actually teaching, they're not protected by the First Amendment. So that's why these board policies really do matter. They really do apply. And that's because teachers are public employees. So their speech while they're doing their job isn't considered to be the protected speech of a private citizen. So depending on whether a bill passes this spring and what it actually says, because the bills proposed last legislative session were a little bit different from each other, as have the bills that have passed throughout the country. Some questions that teachers might want to consider are whether their lesson is connected to the district's approved curriculum, whether they've checked their school board's policies and followed the procedures there, whether they're using age-appropriate resources, and sort of as a last resort, and this one especially really depends on what the bills are and whether they pass, is whether you've considered alternative settings to present the controversial material, such as extracurricular and optional opportunities. And of course, it's not in quotes there, but when I say controversial, I mean controversial. As long as teachers are following the curriculum set by their districts, parents don't have a legal right to tell teachers what they can and can't teach. In Missouri, parents do have a statutory right to voice their opinions on curriculum, and school districts are supposed to encourage this interaction. As I think many of us have seen, parents can show up at school board meetings to advocate for their preferred curriculum, though the school board will have the final say, as I said in a couple slides ago. Parents can have more specific rights about what the children and youth they're responsible for are learning under opt-out statutes. Sometimes states create opt-out statutes that allow parents to decide whether to have their students avoid taking certain courses or learning about certain topics. That being said, there's no general opt-out statute in Missouri, and there isn't currently an opt-out statute specifically for instruction relating to equity topics. There is a specific statute related to sex education, and there's a broad opt-out protection in, say, Texas, but Missouri doesn't have one specific to equity education. The lack of a general opt-out suggests that Missouri districts aren't required to honor opt-out forms for anything other than sex education. Missouri school districts can decide if they want to accept opt-out forms from outside organizations, or they can create forms themselves regarding curriculum that aren't pertaining to sex ed.
I'll just say the reason we put this in here is because I think many of you probably have seen there are these forms circulating. I think Missouri Prosper has created one that they're having parents use. And so we really wanted to kind of dig into that and sort of be able to confirm that it really is up to the district whether they would accept that kind of form.
Yeah, I think that's sort of the theme of at least this part of the presentation. A lot of the decisions are made at the district level. Whether students can opt out, what the actual curriculum is, what teachers can and can't do. A lot of that's decided by the district. In terms of students' rights, I mean, I talked about teachers, I talked about parents, I should probably consider the actual students. Students do have free speech rights under the First Amendment. The Supreme Court famously said that students do not shed their constitutional rights to freedom of speech and expression at the schoolhouse gate. Students have the right to speak out, hand out flyers and petitions, and wear expressive clothing at school, as long as they don't disrupt the functioning of the school or violate school policies that don't hinge on the message expressed. Some courts and legal scholars also suggest that students have a right to receive information through the First Amendment, though the Supreme Court itself hasn't clearly decided this.
Which means that like a student has a right to read a book that they want to read.
Or be taught certain things around equity, to learn American history. I think we've also unfortunately heard a lot about backlash to people who are exercising their rights or advocating for the rights of others. Hopi and I are both education lawyers. We're not experts on harassment, but as a general matter, if you're exercising your rights as a parent, student, educator, or community member, and you're experiencing targeting or harassment, there might be additional legal protections, like under harassment laws, defamation laws. We suggest generally to document everything and block or report online harassers, and consider seeking legal assistance.
Yeah, I think there's in the works sort of an effort to get maybe a list of folks who would be helping with that kind of thing. Like Elizabeth said, that's not really our area of expertise. It would more probably be a tort lawyer, but just wanted to make it known to everyone that, you know, there are those protections out there. And so, yeah, thanks, Elizabeth, for going over all of these rights. And we can definitely go back if anyone has any questions about any of those particular rights. But the other kind of thing that we wanted, the information we wanted to give, especially as I think we're sort of approaching the pre-filing legislative session, just to get everyone sort of thinking about legislation and the legal considerations of a bill that could be filed in Missouri. What we would look at as lawyers, both as the bill is, you know, maybe being filed, but also after it's filed, what could happen, what could be done to maybe challenge it. So just a huge caveat is that there is not a current bill in Missouri that is, you know, proposed and actively being worked through the legislature. As I think many of you are aware, there was one in the spring session that was filed, and then also in the summer session, a slightly different bill. And so we are going to reference that a little bit, but just the caveat is that a lot of the legal analysis that we're able to do is very much dependent on the text, the exact language of what ends up in that bill. And so what we'll do is give you kind of some things to think about. But just know that this all could totally change depending on what type of thing is pulled by the legislature. I mean, we've seen some kind of crazy creative types of bills lately coming out of certain states. So so that's just the caveat. But the lawfulness of a particular bill can be challenged in court after the bill is passed. In certain instances, also, if there's like a chilling effect, could maybe be before it's passed, but generally after a bill is passed is when you would bring a lawsuit, basically. And so this is just the caveat. These are some other states that have already passed bills or that have considered passing bills that are anti-equity bills. That's kind of what we're calling sort of a catch-all term for any bill that is attempting to restrict the teaching of concepts about equity, diversity, racism, race, I think you all are kind of familiar with what that kind of encompasses, but you know, we're not, some of these are going to use terms like critical race theory, and we all know like that that is a very intentional strategy. So we're just calling these anti-equity bills. But the other thing, I guess, to consider in addition to the exact language of the bill itself in Missouri would be whatever happens in other states. And I'll kind of explain why that is so important. So just to take a little bit of a dive into why the text of a particular bill is so important and looking at the legal implications, we'll look at this example of Missouri's House Bill 1141, Amendment 23. This is the one that was filed in the spring. And that would have prohibited school districts and their personnel from teaching, using, or promoting any curriculum implementing critical race theory. And if you want to look at the exact language of this bill, I can, you know, we can link it in the chat if we want, but generally this bill was using the term critical race theory in a way that could have captured a lot of what, first of all, it left a lot up for interpretation, but it could have captured a lot of diversity, equity, inclusion efforts, as well as different lessons and discussions about historical events, real history, and generally conversations about race. And it was written, sort of the first part of the bill was written very broadly and kind of vaguely, so that it was actually unclear what it would affirmatively cover. There were, you know, educators totally confused. Even the legislators themselves kind of didn't know exactly what it covered. There was another part of the bill that specifically called out a list of specific initiatives and projects, specifically banning the use of the 1619 Project, for example. In the version of the bill that was introduced in the spring 2021 in Missouri, there were not any explicit enforcement mechanisms or penalties written into the bill, which is kind of a key thing that could affect the sort of challenges that could be brought as well. I think somebody just posted in the yes, I think can share this presentation with the people in the MOEB group. I will double check with our managing attorney, but I think that is probably okay. We also have actually a flyer that has a lot of this information too, so we can share that too. So that was kind of one example of how a bill like this could be written. But just to show you the variety of the types of language that are being used currently in this like nationwide movement forward to try to get this kind of bill passed. Other proposed bills and bills that have already passed have used different framing. So for example, in New Hampshire, there's a bill that talks, instead of saying critical race theory and defining that term, they use this term divisive concepts, which was also actually used by a federal executive order under President Trump. That's similar, that's how they defined what they were trying to ban. In Iowa, the bill instead uses the term race and sex stereotyping, and actually goes on to have quite a lot of different exceptions. So the way the Iowa bill is written is that it bans race and sex stereotyping and kind of defines what that is, and then it actually carves out a lot of exceptions for what is banned, meaning that there are still certain things like that are taking into account students' rights that are incorporated into it. It's still limiting a concept that I think many people, all of us on this call, probably would want to not be limited, but it's doing so in a way that that is kind of carving out some of those exceptions. And so the legal implications and the ability to challenge it are sort of accordingly a little bit different than in other states that have really broad language. So another example of an enforcement mechanism is like in Tennessee, the state can withhold funds from districts in order that are not complying with the bill. So that would be an example of an enforcement mechanism. There are other states, I'm losing which ones they are off the top of my head, that actually as enforcement really are focused in on individual teachers and educators who are violating the bill. So really, as we as lawyers are looking at a bill, we're looking kind of at who are the people affected by this bill. Is it really mostly just to administrators? Is it mostly to maybe even state level officials? Or is this something that also is using obligating binding language toward educators themselves, and maybe having implications for their termination or for discipline of some sort? We also have seen in certain states an attempt to ban equity instruction and trainings for all government workers versus just those in public schools, which was kind of the focus of the Missouri one. So I think you can tell from all of this that the exact language in a bill and exactly, what the written effects, who's affected, all of that really can affect the legal implications, especially how broad or narrow the bill is.
And so I think that sort of explains why I had to speak very generally about the rights of students and parents and teachers, because until we get the text of, until and if a bill is passed, we don't know. And frankly, under a lot of these bills, even if they were passed, we probably still want to know. A lot of them aren't very clear on what you can and cannot do. And that is one of the many reasons why.
Which in and of itself, though, is legally significant. I think that's kind of the point that we're yeah, but it's exactly right. That's why kind of as we've been trying to think of, what type of know your rights information is helpful, it's, it's all sort of with a little bit of a generalized caveat. So yeah, revisit us if there's a bill.
Yeah. If we could just give you like a nice little checklist of like what is and is definitely legal, what is and is not definitely legal, like we would, but we just can't at the moment.
So another little, just kind of wanted to give you a little bit of a 101 about how a court would look at a challenge to one of these laws, just generally kind of how a lawsuit works as well. So why it's so significant to look at the people who are impacted by the law, who are like named in the law as, a category of people maybe who are obligated to follow it, is because that can determine then who can really bring the lawsuit, who has standing to bring a lawsuit. Some, depending on the language of some of these bills, sometimes that includes students, if students are implicated directly, sometimes it's just districts, sometimes it's parents, sometimes it's educators. There's a lot of different players in this, as you all know. And so that's one thing a court would look at. Another thing is just looking at, when you file a lawsuit, it has to be in the right court based on whatever claims are being made. And so a court would look at, are there federal laws being implicated or state laws? And so that would determine whether you would be in federal or state court. And then whichever court you end up in as the correct court, that court looks at what's called precedent. So that's other decisions by courts that are in that world of courts that have decided on past similar issues or on the same issue. So for example, if you are in federal court in the District of Western Missouri or of Eastern Missouri, the district courts in Missouri are in the 8th Circuit, which is a whole group of courts kind of in the middle of the country. And so you would look at not just what the Missouri District Court has issued on past cases, but you'd also look at 8th Circuit decisions. And then the Supreme Court is the law of all the land. And so you would, whatever the Supreme Court says is like the most binding authority on any court. And so that is why, depending on what state you're in looking at a challenge to one of these laws, there actually could be different parameters for what kind of challenges or claims would be viable. And finally, a court is going to look at basically what is the remedy being asked for. What are you actually asking the court to do? Is it to overturn the law? Is it for them to declare that the law is unconstitutional? or issue an injunction, like stop it from being enforced or implemented. So that's sort of another consideration that a court would look at. And if there isn't something that the court can do in its power, then the lawsuit, can't move forward. So as just an example of that, key concept of precedent, I don't know if this is if this comes as a surprise, but there has not been a ton of court cases looking at the specific issue of teaching about equity and diversity in curriculum, or really teaching and training, this whole set of issues, I think that these different bills are trying to look at. Not a ton of direct precedent on point. One example that is kind of in this world is a court decision that happened last year, basically around the executive order that Trump tried to pass, prohibiting the teaching of divisive concepts, basically to federal employees and contractors. And in that case, the California court did say that was that basically that executive order was unconstitutional. Just keep in mind that a California court might not rule the same way as a Missouri court, just one additional consideration there. But in that case, there were two claims that were brought. And so the California court found that this executive order violated the plaintiffs were a group of people impacted by this, violated their rights under the free speech clause of the First Amendment, based on content and viewpoint. So that's kind of one legal theory under the First Amendment, is viewpoint discrimination. And the other claim was brought under the Fifth Amendment, and it was found that this executive order was void, what's called void for vagueness, basically meaning that it was too vague to give people notice of what was required, and what sort of constitutional parameters there might be affected there. So I guess the reason to bring up this example of how that California court ruled on these two claims is just to say that how a prior court has ruled on specific claims like the free speech, First Amendment viewpoint discrimination claim. That is something that can affect then what other courts, again, keeping in mind that California is not in the same circuit as Missouri, but that other courts might look to. And so that is an example of some federal precedent on this issue. Again, it's not exactly on point, though. You can, I think, look at this and see the various reasons why this is slightly different from whatever would end up in Missouri. One is that this is an executive order and not a state legislature having passed a statute. So that's kind of how a lawyer ends up looking at any type of precedent, is like, what's similar about this? What's different about it? How could we apply it to the case at hand, or distinguish it from the case at hand if you're trying to not get the court to look at that precedent? And then sort of on the state level, an example of laws and precedent that would be at play potentially in a Missouri challenge in this way. Like I said, one thing a court looks at is whether they're the right court to be in, and not to go all into civil procedure, but basically if you have any sort of federal claim, you'll probably end up in federal court. And that's a little bit of an oversimplification. But if you're in state court, there are, oftentimes state law parallels to some federal laws, especially constitutional law. So for example, Missouri has also a free speech clause in our Constitution that's kind of similar to the federal First Amendment clause. And so that's something that could be implicated in a state law, in a state court. And just wanted to point out another sort of Missouri statute that is out there that a court might have to sort of reckon with, is that we actually have a statute on the books that says that American history courses have to include specific referrals to details and events of the racial equality movement. So depending on the language of whatever bill Missouri ends up with, there may have to be some sort of court examining how to harmonize that with this existing statute. So the court's going to look at existing laws like constitutional law and statutes, and then also case law, which is prior precedent decisions that have been made basically about those constitutional law and statutes. So that's all what a court would kind of look at. And so kind of given all of this, I think that I've sort of touched on most of this, but some of the open questions as we are, still without any sort of bill, which is fine by me, we don't have that bill yet. But we're, sitting on some questions that are kind of still swirling about, given how this might be implemented and how it might be written. So, there is that question of enforcement, which could affect who would be able to challenge a law, whose rights are maybe being implicated if they're going to have the bill enforced against them. Another question that we have is DESE, the State Department of Elementary and Secondary Education, going to weigh in at all? Are they going to have any sort of guidance? That's something that could influence districts in their decisions, and also then be telling about kind of how the state is looking at this issue. Of course, as Elizabeth went into detail about, district board policies are key, and as we all know, there are a lot of different approaches that different districts in Missouri are taking around this issue already. And so what a district decides to do in terms of guidance and messaging to educators is really important to understand, and for really for folks to track. I'll get to that in the next slide, but that's where sort of the rubber is probably going to meet the road in Missouri, given how much local control there is over curriculum. And then, like I said, whatever happens with some of the legal challenges that are moving their way through the courts in other states that have already passed bills like this is going to create precedent that then a Missouri court would have to look at. And so that's why it's also important to kind of keep in mind what's happening in other states, especially other states that are in the 8th Circuit in like sort of Missouri's geographic region. Those are going to be the ones that Missouri courts would be most needing to follow, if that makes sense. And just another little reminder that if there are any questions you have about specifically as maybe an educator about your employment and how this affects employment, that would be probably something for a district attorney. So I did just preview, and I didn't write this out because I think that we were happy to sort of send this in an email to someone, but just wanted to kind of like orally say that from a strategic standpoint at this point, we know that even the threat of a bill passing is already affecting people on the ground in districts, students, teachers, parents, all of that. And so it's not too early to kind of start tracking what's happening in your district. Are there stories of books being taken off shelves? In fact, I have a whole list of things that we can think of. Like are students not having access to books that were in the library or on their reading list? Are they not being allowed to choose certain topics for presentations or for projects? Are students being told that they can't talk about certain topics in class? Those are all kind of like stories that you may already have about how students are affected. And again, if students end up being implicated somehow in this bill, those are good things to know. Similarly, tracking stories about teachers and what messaging teachers are getting from their districts about what they can have in their curriculum and on their syllabus in their classrooms. Are they being told they have to take certain books off their syllabus? Are they being told they can't discuss certain things in class, or have to take down posters or signs in their classroom? And especially, are they being threatened with any sort of discipline or, again, any sort of enforcement if they don't comply with sort of what the district is guiding them to do. And for any of these stories, kind of taking note of like what administrators or district officials or state level officials were involved, as well as the setting where an incident took place. Was it in the classroom? Was it outside of a classroom? Those are all like good things to understand. And in terms of data, also just like I think zooming out and seeing kind of from a more systemic level, like the trends of what's happening from district to district. Really, I think like MOEP already is doing such a good job of having a presence in many different districts and trying to understand what is happening on the ground. And so I just like am grateful to, I think, get to hear from all of you and get see the work that is being done by MOEP on this issue. So just wanted to kind of plant some seeds, I think, flowing from our discussion of the rights and the players involved, and then of kind of what legal considerations there are, flowing from all of that. If you're asking kind of like, yeah, what can I do? What can I start thinking about? Those are just some ideas for kind of what to think about. And I think there's something else. Okay. So I think that's what we have for now. So we have a little bit of time for questions. This is our contact information of the Education Justice Program. I will open it up to see if anyone has.
So of course, you guys in the presentation, right at the moment that my mom has texted me and told me that my sister got a well-earned promotion. And so I'm like, because I cried everything and I'm just so proud of her. And so let me try to get my thoughts together. For some of the questions that people posed, I think that a lot of the questions you all actually answered or approach it. But one of the questions is, what kinds of obligations do candidates for public office have as far as responding to inquiries or comments, especially hostile ones, on social media? So if a member, if someone is part of a school board, or someone is part of a city council, what type of obligation do they have to respond to all of this negative feedback on social media? Or do they have any type of legal responsibility?
I am going to say I don't know the exact answer to that, but can look it up. But just so I know and understand, are we talking about like a public official who maybe supports equity instruction? Like maybe if I can have more of like the specific instance and kind of like,
yeah. So if that person supports equity instruction or equity, in an equity inclusive curriculum, and people start inquiring that are on the more hostile side, what obligation do they have to respond to that? So that was one of the questions. One of the things that I used to teach my students all the time is it's okay to say that we don't know and we'll get back to you. And I used to do that with my kids too. So if we can't answer that question here, then we will try to get back to you about that.
We'll have to do that. We're not experts in what public office holders can do, unfortunately, but
right. I get it.
I'll get back to you on that.
Oh, this is let me look. I'm trying to find the ones that are within you all's wheelhouse. What kinds of legal challenges are educators facing, and how can we support them?
our educators facing, like as in our educators being sued?
Right, our educators that are implementing equity-based. I will just tell you that today I met two teachers in my own children's school district. Actually, two teachers at the school where my middle child graduated from. And one person told me she is scared as a social studies teacher if she's in the middle of teaching about slavery, and she's scared to bring in supplemental information. She's scared to do anything besides what is in the approved text. And one of the things that we know, as you know, I used to be in the classroom. One of the things that I know is that our textbooks don't always cover the whole thing because it is based upon Texas.
Yeah.
One of the things that people don't realize about textbooks is that Texas has a really huge role in determining what textbooks are approved throughout our entire country. And so when we look at some of the material, it's not telling the full story. And so basically, what can we do to support our teachers in this particular situation? You know, that is legal. That from a legal perspective, what are our rights as far as advocating for, and then for our teachers and protecting them as best we can.
Right. And let me go back to the teacher slide, because that's a really good question. I think that's something that has been coming up a lot. And I think that's one reason we kind of wanted to do a dive into like some considerations for educators. I think one thing that hopefully is empowering to educators is knowing that, like, first of all, like, parents can't tell you what to teach. That's not where that's not where, you know, your teaching obligations come from, and that's not the limit on your rights. So hopefully that's kind of empowering. And in addition, there are, I think, well, without saying, you know, specifically exactly, again, we don't have a specific bill, so kind of that legality is difficult, but generally, I think that there are ways that, you know, that parents, that teachers kind of in thinking about all of this, like, can still do, you know, a lot of the things that they were doing. Of course, if they have a specific question about a specific thing, you know, feel free to maybe, you know, have them ask us or something, because sometimes that can get a little fact specific. But generally, if you're wanting to support teachers, I think, like, just supporting them in the way you would support really them on any other issue of, like, they're feeling burned out, they're, you know, working really hard, like, showing up, you know, I would just imagine that, like, as teachers are people too, like, showing just genuine care in just a very human interpersonal way goes a long way. And from sort of more of like an advocacy and legal standpoint, another thing that comes to mind is showing up at school board, which I think Moeep is already doing, showing up where you can voice your support for the kind of you know, instruction maybe that teacher wants to have in the classroom. And I think then again, telling them that, you know, if they have questions about like specific things that they're teaching, they can ask, but that generally they, again here, it depends on sort of what the district is. If they're getting messaging from the district that is making them feel that fear, you know, that's first of all, something we would kind of want to know about, of just like, exactly, is the district telling them specifically that they can't use that book? You know, or is the fear coming from, which is super understandable, just like the general, you know, controversial nature of all these conversations right now in our society. And I think kind of encouraging a teacher to sort of sort that out in their individual case could be helpful. to the question in the comments, I'm sorry, I might need to scroll back, but just the one I just saw, have lawsuits been filed in the states where anti-equity bills have been passed? Yes. Most recently, there was one in Oklahoma. The lawsuit, the pleadings are, I think, really well done. It's really great. It's great to read through, I think. If anyone's interested, I think we should be able to link that. We can drop that in the chat. Again, I think you'll see that that's yet another, the way that that bill was written was in yet another different way. And so a lot of the way that they framed that challenge was based on the specific text of that bill. But I think generally, like, the scope of what it's covering is interesting to see. So I can try to plop that down. I believe there are some other ones too. We are actually going to be trying to really start tracking that. And that's, I guess, I don't mean to say that we'll do it alone. If Moeef also is interested in doing that, then that's something that I think could be a good step for all of us to understand better.
Yes,
Let
if
me
you
go
could
back.
please let us know those links. I don't know if either of you could email them to me so that our Marcom team or myself can kind of go through, because well, I'll wait and let you all ask whatever questions you have.
I think there are a couple other ones in the chat that I'm going through. So, okay, so should you block someone that's harassing you on social media, or is it better to leave their comments there and just document? That, I think, is going to touch on something that's not really quite our expertise. I think my instinct, and I don't also know how exactly social media blocking works because I am not that savvy with this, but document definitely whatever you have, like if you can do a screenshot or something like that, whatever there is. I wouldn't delete something without screenshotting it, but I also don't think that you need to subject yourself to constantly seeing that. And so again, I don't want to give specific advice on that, but I think, yeah, I'll just leave it there.
Ryan has a great question too. Are these anti-equity bills written to be intentionally vague to basically cause problems, or is it because the architects of these bills don't really understand education? Before we get their legal opinion, I will just say yes. The answer is yes. It's both of those. Okay, go ahead.
Yeah, I think that's what I would say too. I mean, just the interesting thing is actually, like, the vaguer something is written, probably the more susceptible it is to a lawsuit. So it's they're kind of shooting themselves in the foot if that is what their strategy is. So
yeah, the lawsuit that Hopi was talking about earlier, about around that executive order, she was talking about how it was void for vagueness, which is a legal term, meaning that it's like, it's so vague you don't know what it means. And
so, right, how can you enforce it?
Constitutional, yeah.
Right.
And it's pretty clearly unconstitutional. So yeah.
In terms of the strategy around it though, I think that there've obviously been different variations of these bills. In Missouri, I think that there were like 3 bills or amendments filed last spring, and then another one over the summer during a special session on Medicaid. And obviously they've been filed all over the country. Some have been different, some have been kind of similar, which makes it seem like they're coming from certain places. So I can't speak to the overall strategy of it being vague, but I think that there's been some, learning from each other in writing these bills.
I can speak to the vagueness of it. They can't, I can't. So I will say this. One of the things that we have to realize is that this is a wedge issue. And this is a wedge issue where basically they're politicizing an issue so that they can activate their base. And in the end, that's what we have to be really aware of. One of the things that we're working on at MOE is coming up with messaging that we can pass on to all of you. So just like some of these individuals are literally receiving sheets that tell them, here is what you can say at the board meeting. Here is what you can, really be upset about. As they're receiving all of this messaging, basically what we want to do is make sure that you all are armed with that information as well. And so that is one thing that we're working on. Another thing that we're working on is cultivating a list of attorneys who are capable of helping to protect our members. And that means teachers, that means administrators, that means parents that are part of the school districts, etc. Another thing that we are really trying to cultivate is a list of people who are willing to testify in front of the Missouri legislature, and that includes students and parents, as well as teachers and administrators. The thing is, really, with these individuals, what will move them most are teachers and, our students and parents, because they can spin what a teacher says. They can spin what a leader of an organization says. They can spin all of that, but they can't exactly spin what students say and what parents say as much. So we're working on all of that, and please look forward to it. I know that sometimes at the grassroots level, the just boots on the ground level, it feels like things aren't happening, but I can let you know that a lot of things are happening. A lot of conversations are coming out, and a lot of collaborations are being created to make sure that our boots on the ground are prepared and ready for this fight. And it will be, we know that in this next legislative session, we are going to have individuals who are, advocating for banning all types of equity education. That's one thing that we know. The next thing that we know is that there are groups out there who are petitioning for to flip school boards and to, to flip school boards and to make sure that these very vocal, and I would like to say minority voices are part of the decision-making process. And we need to push back against that as well. And so we're going to be working with all of that. And I know that, again, Hopi, Elizabeth, I can say it. I can say stuff that you can. So we thank you for this. Are there any more questions?
Yeah, thank you. Thank you all for letting us chat about this, and for showing up, and for doing all that you're doing, in whatever capacity you're in. I think this takes a lot of different people doing a lot of different things. So we will, I think, be able to send the slides, and we can also send the Oklahoma lawsuit and the flyer that we have. So let me know if there's anything else, but thanks.
All right. Thank you all so much for coming.